what is the reason being preferred in this case? When we go back to yesterday, the state requested a postponement so that they could consult with their witness. Something that is totally unacceptable. You do not consult with witnesses and decide whether you are calling them in the middle of the trial. This matter was before you on the 1st of October, 2021. And my learned colleague clearly confirmed that they were ready to proceed with the trial. We also confirmed that we were ready to proceed with the trial. Almost 2 months later, it becomes apparent that the state was not ready to proceed. In fact, they do not have witnesses. That was yesterday. They've consulted who they consider to be their witness. The witness is here. They're not calling her. That is a mockery of the system. Wasting the witness's time to travel from African to come to Johannesburg, only to be told we will not call you as a witness. Abuse of power of the state at its best. Now, what is the reason being advanced today? You are told there's a witness called Mr. Magwaza, that it is their only witness, that he is not here today, and of course he was not here yesterday. The witness they have not consulted with yet. And obviously these consultations could have happened before the accused was summoned to come to court in September. We are in November. Why is the witness not here? We are told that the witness needs to be assisted with traveling expenses as well as accommodation expenses. Of course, and that is acceptable. You are also told, Your Worship, that the prosecution is going to prepare a memorandum to the office of the Chief Justice or whoever to approve the expenses. And it takes 3 to 4 weeks for that approval to be obtained. From the 1st of October is end of October. Not from tomorrow. They should have done that from the 1st of October after you set the date for trial. They did nothing. And they tell us today they're going to do it. And it takes time. So this trial can continue next year in February. With respect, I submit, Your Worship, you must not accept it. It is an insult to the system. Waste of your time, our time of the witness, and of the accused. So in essence, there is no good reason before you for you to grant a postponement. The only reason being preferred is that they need 3 to 4 weeks to submit a memorandum and get approval for traveling expenses and accommodation expenses of the witness. That is not a good reason, especially when they had time from the 1st of October to do just that. It's an administrative matter. It would be something if they were saying the witness is not available because he is indisposed or something like that. But no, it's administrative. And they tell you with arrogance that they're only available in February because they've got other commitments. And we are not even told what kind of commitments are those. Of course, December is around the corner, people are going on leave or on holiday, but we're talking about the administration of justice. That is also not acceptable. I don't have to address your worship on the prejudice the accused will suffer. It's obvious. Over and above not being able to do their work, there is cost involved for the 3 days on which this trial was set. Under circumstances, Your Worship, I respectfully submit that you have no option but to refuse the granting of the application. Thank you, Your Worship.
This is a call, Mrs. Worship. What the state indicated yesterday and today, Your Worship, was that the witness, we were supposed to have made arrangements with the witness that we're not calling now. We were supposed to have consulted with her. Now, the only communication that we have with her was the cell phone that she gave to the investigating officer. She was contacted twice, telephonically. 2 messages were sent to her as well. Yesterday when I took up with her, she said she never received the call from me. She never received messages from me. I eventually then showed her the messages that I had sent to her. She then admitted to say, in fact, she did receive those messages. She just ignored them because this was a number that she did not know. Hence, initially, she was the one that phoned me to say she needed us to make arrangements for the consultation because we had sent the investigator to do that. So therefore, we submit that cannot be said that we now arrogantly, as it is put, using or abusing the state's power. There's nothing to do with that. It's something that had to do with us being able to get to the witness. The witness herself indicated to the investigator that she is based in 2 provinces, being Northwest and Limpopo as well. So the only way that we could get through to her was through the cell phone. And if she's not answering the phone, if she's not responding to the message that I sent, there wasn't really much that state could do with the so-called powers that the state, we are told, has. The state's powers are not that powerful. They are very limited, in fact. Now, it was only yesterday when she came. She didn't have a reason as to why she did not now respond to our messages or avail herself for the consultation. Furthermore, we are not saying that it will take 3 or 4 weeks for the approval of the memo. What we are saying that the process in arranging the accommodation might take up to 3 weeks or so. Because now, yes, the memo has to be drafted, then it will have to go to people that have to approve it, then it has to go to the agency that arranges accommodation and traveling.
Why must this witness come and sleep here if he's coming from KZN? He can just come and go, essentially.
Indeed so, but we must then bear in mind that we don't know if the witness testifies, will he finish his evidence in 1 day? Will the cross-examination last for an hour? Will it last for 5 minutes? Will it last for 2 days? We don't know. And this court cannot even curtail that the cross-examination by the defense to say, I'm only giving you 10 minutes to do cross-examination. They will have to do cross-examination to exhaust all the issues that they would want to take up with the witness. So now, we have to have that proviso that in the event that this happens, the witness is going to be stranded here. And the witness will be looking at us now to provide accommodation which is not being arranged. So we want to cater for that as well, that in the event that this happens, because it's an eventuality, it has happened many times with our cases, where only 1 day is arranged for a witness, but it happens that then the matter overlaps or the testimony overlaps to 2-3 days. So we submit that in as much as it is prejudicial to the accused, we submit that the court needs to balance, of course, the prejudice, the rights of the accused, vis-a-vis the interest of justice as well. The bulk of the evidence in this matter, we submit that it's already before court. The transcript is the one that we are mostly relying on. The witness that is being called is a witness that will be corroborating just what is on the transcript. But our main evidence already is before court. It is through this transcript that we are saying that she committed the offense that we are alleging she did. We submit, Your Worship, that the reasons that we have provided as well, even the witness in KZN, it was due to the issue of us not being able to get through to him on the cell phone numbers that he gave as well. So it was something that was unforeseeable to the state.
Coincidence because his telephone number were issue. It's such a coincidence.
And unfortunately, if the court put it that way, it's unfortunate. But that is what happened. The investigator, we can even call the investigators have to be here to testify about this issue. We would love to put this matter to rest as well. We would wish to finalize this matter as well. As to the explanation, whether this is suspect or not is something else. If the court wishes to have the cell phone records to show that these numbers were phoned, that's something else. That can be made available if the court doesn't take the weight that I put into this court. I'm the officer of this court. There's no need for me to come and lie to this court and say this is what transpired, whereas that did not happen. The phone calls that we're talking about, those are the phone calls that I made myself. And as the officer of the court, I'm putting the court, or I'm basically telling the court what exactly has transpired.
It's really finding it difficult to understand the state critical comments in securing those witnesses, especially not just one of them.
That's the conclusion.
All these days that has been allocated for this matter. I'm really finding it difficult.
It did so, Your Worship. We can't really say much about that, but we have put across to this court as what has transpired, what attempts the state made to get these witnesses to court. And that is the best that we could do.
I'm now failing to find the state trying harder to secure the witness. I'm really not seeing the efforts on the side of the state to ensure that at least the witness is here. We set this matter for 3 days.
Yes, as a court president.
So that is my difficulty. I'm not yet convinced that the state has put in sufficient effort to secure the witness. And the reason that that has been put across for me, I'm still battling to swallow them, to understand.
Well, I don't understand, but I'll have to accept what the court is saying. I'll have to accept what the court is saying. If the court is not accepting, with respect, there isn't really much that was.
Because from what I'm gathering, with due respect, Advocate Serafo, is that even no efforts for securing him to be here even today, and no efforts with an anticipation and an understanding and an appreciation that it can take 2 days to at least make sure that, okay, let's force matters and put up all the stops and get this witness today at court. Because if you can't finish it today, I'm sure you knew yesterday that this one witness intended to call and you consulted with. Wasn't then your decision yesterday that you are not now calling this witness? Then your efforts should have been now, okay, this one is down, but let me focus on getting this one now. You still have 2 days. What can I do to get this witness at court at least tomorrow? At least if this witness is not finished tomorrow, I know Friday also there's another day. I'm failing to get that from the state's perspective. What has the state done to? I don't want this red tape story because Dr. Huddle, it's just not a serious hurdle. That cannot be crossed in my view. So
It's fine. There's a problem. If the court says that we really didn't put much of an effort, it's unfortunate, with respect. However, this court can make an order now instructing the court manager to make arrangements for the witness to fly overnight or to come tomorrow morning, to come testify tomorrow. That is not a problem. We don't have an issue with that. We are available for us to prosecute the trial. We're not saying we are not available. We are available to prosecute the trial. It's a question of because now, can the court manager of this magistrate's court quickly make arrangements for the witness to make himself available tomorrow? And so the witness can fly over to come testify tomorrow.
Well, by all means, it looks like matters are going to have to be postponed again just based on that little interaction. But we'll take you back there as soon as we're able to. But let's go to a break for now.